Supreme Court of India has once again decided about the limitation period under insolvency law, specific to powers of NCLAT to condone delay in filing appeals. This was decided in the case of Tata Steel Limited versus Rajkumar Banerjee on 7th of May 2025 by Mr. Justice J.B. Pardiwala and Mr. Justice R. Mahadevan. Now, in this case, the facts of the case, the appellant in this case was Tata Steel Limited, the successful resolution applicant of Rohit Ferrotech Limited. Rohit Ferrotech Limited is the corporate debtor, and the respondents was Rajkumar Banerjee. Rajkumar Banerjee is erstwhile minority shareholder of the corporate debtor, and other unnamed respondents were also there. The resolution plan was approved in this case in June 2021, and it was approved by NCLT Kolkata on 7th of April 2022, and this respondent number 1 filed an appeal before NCLAT. He was not a party to CIRP, as he was an erstwhile minority shareholder. He was not attending the meetings of the CIRP, and he filed an appeal under Section 61 of IBC. The timing of the appeal, since the NCLT passed this order on 7th of April 22, appeal was e-filed on 23rd of May. E-filed on 23rd of May, that is after 46th and 47th day. So after 46th or 7th day, physically it was filed on 24th. So e-filing on 23rd May, and it's a physical filing on 24th of May. And that is 46 days and 47 days. Technically, delay, e-filing delay 1 day, physical filing delay 2 days. However, an application for condonation was filed, and NCLAT allowed the application and condoned the delay. And this particular condonation was subject matter of the appeal before Honorable Supreme Court of India. The appellant, which is Tata Steel Limited, in fact said that the limitation period under Section 60 subsection 2 is only for 30 days. And the extended period, which is maximum 15 days, that is only can be condoned by the NCLAT, and NCLT doesn't have any power beyond that. So the maximum days which are allowed is 45 days and the working day argument. Now, what happens is, this is very, very important in this particular judgment, because the limitation period applies only to the main 30 days period. It does not apply to the extended period, which is supposed to be condoned by the NCLAT. Now, the last date of limitation was 7th of May 2022. It was found that was a working Saturday of NCLAT registry, and the registry was accepting the applications on that particular day. So therefore, that limitation, Section 4 of Limitation Act, was not applicable. So the applicant also said that in various other cases, like V. Nagarajan versus SKS Ispat, Kalparaj Dharmashri versus Kotak, Sapphire Technologies versus RPFC, and Ajay Gupta versus Raju, all these legal judgments were in fact presented by Tata Steel Limited to Honorable Supreme Court. Now, the respondent, that minority erstwhile shareholder, said that the knowledge of the order, he said that he was not having any knowledge of the order because he was not party to the CIRP. So when this order was uploaded on stock exchange on the very next day, he came to know about that particular day. So therefore, that 1 day is excluded because he came to know about that order only a day later. So for him, the limitation period starts on 8th of April and not on 7th. No, look, the entire fight is for 1 day. Entire fight is for 1 day. And he was also saying that holiday extension. He was saying 8th of May 2022 was a Sunday. Benefit of Section 4 of Limitation Act must be extended to him. And therefore, the limitation period must be 9th of May in this case. So filing timeline, that was 24th of May. that was within 45 days. So therefore, this was the argument from the respondent. Now, the legal issues framed by the court, whether the appeal was filed within the limitation period or not, whether NCLT can condone delay beyond maximum 45 days or not. In this case, the provisions which were being considered was section 61 subsection 2, which says that it is only 30 days which are allowed. And beyond this, only 15 days can be allowed if NCLT is satisfied that there was sufficient cause for not filing the appeal, but such period shall not exceed 15 days. And also section 238A of the IBC, which says that the provisions of Limitation Act shall, as far as may be apply to the proceedings or appeals before the adjudicating authority or before the appellate authority or even the debt recovery tribunals or even the debt recovery appellate tribunals. Limitation Act provisions. Section 2J, Section 4, Section 12, subsection 2 of the Limitation Act. Also Rule 3 of NCL 80 rules. All this was considered and this was being discussed. Supreme Court, observation number 1. In the present case, respondent number 1 was neither a party to the proceedings before NCLT nor privy to the COC deliberations and became aware of the order only upon its subsequent disclosure. However, it is evident that the company secretary of the corporate debtor duly informed the listing department of both NSC and BSC about NCLT order dated 7th of April 2022 within 30 minutes of its pronouncement. Within 30 minutes of its pronouncement, that is the requirement under the SEBI and stock exchange norms, because this is an important order. So therefore, it has to be uploaded within 30 minutes of its pronouncement. That was what the Supreme Court said, that this was definitely, one thing is very clear, that the becoming aware of the order is a right reason. It is a genuine reason. However, in this case, the Supreme Court found the fact that it was uploaded within 30 minutes of the pronouncement. So therefore, there was no delay. There was no delay from the appellant side. The court further observed that the limitation period under section 61 subsection 2 is 30 days from the NCLT order, extendable by a further 15 days only upon sufficient causes. NCLT order was pronounced on 7th of April 2022 and the corporate debtor disclosed the order to stock exchanges within 30 minutes. Hence, limitation commenced on 7th of April 2022. The court further found that the limitation period expired on 7th of May 2022, which was a working Sunday for the NCL 80 registry. Even if Section 4 of Limitation Act were applied, the appeal was filed beyond not only the prescribed period of 30 days, but also the condonable period of 15 days, as it was filed on 24th of May 22. Now the observation number 2. Once the prescribed and condonable period 30 plus 15 days expires, the NCL 80 does not have any jurisdiction to entertain appeals regardless of the reasons for the delay. The court referred to Mobilox Innovations Private Limited versus Kirusa Software Private, which underscores the IBC's strict procedural discipline, that is, only applications strictly conforming to statutory requirement can be entertained. This principle is also applicable to limitation issues under section 61 subsection 2, as it supports the idea that tribunals must operate within the bound of the court without adding equitable or discretionary powers not conferred by statute. The court also cited Kalpraj, Dharamshi versus Kotak Investment Advisor Limited and others, which categorically held that the NCL 80 cannot condone any delay beyond 15 days, even on equitable grounds, and that the appellate mechanism under IBC is strictly time-bound by design to preserve the speed and certainty of the insolvency resolution processes. Commencement. Now let us understand in brief. Limitation commenced on 7th of April 22 because the order was uploaded on time. The limitation expired on 7th of May 2022, which was a working Saturday, and That is the expiry date, but that was not a holiday. Section 4 of the limitation is not applicable because the last day of the limitation was a working day. So therefore, respondent number 1 filed the appeal beyond the statutory maximum period of 45 days, and therefore the court's finding was no jurisdiction beyond 45 days, strict procedural discipline, no equitable power, time-bound designs, no condonation beyond 15 days, and the court concluded that NCL80 has no power to condone delays. Final judgment by the court. In view of the foregoing, the order passed by NCL80 condoning the delay in filing the appeal is ultra vires and liable to be set aside. The Supreme Court set aside the NCL80 order that had condoned the delay in filing the appeal. This effectively barred these respondents from appeal against the NCLT order, approving the Tata Steel's resolution plan for Rohit Faro industry. Now, let us understand the impact of the judgment from the industry. Everyone should strictly adhere to the timelines. The Limitation Act clarification given in this order is very important. Why? Because the original limitation, which is only for 30 days, and when the 30 days expired, it was not holiday, it was a working day for the NCL80 registry. Commercial certainty must be there. That is the only reason why this judgment, because the commercial certainty must be there for all the resolution applicants. Appellate tribunal power is not to invoke equitable discretion or extend limitation, and therefore all the legal provisions that we have discussed and the cases that has actually been again relied by the Honorable Supreme Court is again Mobilox Innovations Private Limited versus Kurusa Software Private Limited. Second, Kalparaj Dharamshi versus Kotak Investment Advisors Limited. V. Nagarajan versus SKS Ispat. Sapphire Technology versus RPFC and Ajay Gupta versus Raju. All this is the judgments used. So this judgment again, beyond various judgments that has been discussed, again emphatically says that the timelines are very, very important for insolvency. So therefore, there is no possibility of condoning even one day. Thank you very much.